In this video, we're going to review some of the rules that we've learned concerning statutes of frauds. Let's start with a definition. Every state has enacted numerous statutes making many different kinds of promises unenforceable unless they are evidenced by a signed writing. These statutes are all called statutes of frauds. Now, what kinds of promises typically are covered? Well, the kinds of promises that statutes of frauds require to be evidenced by a signed writing differ from state to state. Many states, however, have in common statutes of frauds covering the following 6 kinds of promises. The first kind of promise that statutes of frauds typically require to be evidenced by a signed writing is a promise the consideration for which is marriage, unless the promise is promises to marry each other. For example, statutes of frauds typically would require a signed writing for a promise by A to pay $10,000 to B if B marries C. The second kind of promise that statutes typically require to be evidenced by a signed writing is a promise that cannot possibly be fully performed, as opposed to merely terminated within 1 year, such as a promise by A to employ B for 5 years. The third kind of promise that statutes of frauds typically require to be evidenced by a signed writing is a promise to buy or sell land, such as a promise by A to sell a house to B. Now note that provisions in statutes of frauds dealing with land contracts usually are subject to 2 exceptions. First, by tradition, a promise to buy land is enforceable without a writing after the seller has conveyed the property. And second, under the part performance doctrine, the seller may not assert the statute of frauds as a defense if the buyer has substantially relied on the promise to sell. Most courts have said that merely paying the purchase price is not enough for reliance and typically have required the plaintiff also to have taken possession, to have made improvements, or to have performed substantial other actions. The fourth kind of promise that statutes of frauds typically require to be evidenced by a signed writing is a promise by an executor to pay the debts of the decedent's estate out of the executor's own pocket, such as a promise by A to pay B a debt owed to B by decedent C's estate. The fifth kind of promise that is typically required to be evidenced by a signed writing by a statute of frauds is a promise to buy or sell goods for a price of $500 or more. We're going to learn next semester many different exceptions to this rule. But typically, a promise by A to sell a used computer to B for $800 would be a promise to buy or sell goods, a movable object, for more than $500. The sixth kind of promise that statutes of frauds typically require to be evidenced by a signed writing in order to be enforceable is a suretyship promise. That is, a promise made by a surety to a creditor to pay a debt that the debtor owes the creditor, such as a debt by A to pay C a debt that B owes C. Now, when we say that promise has to be evidenced by a signed writing, what are we talking about? Well, statute of frauds typically requires the defendant's promise to be evidenced by a writing essential terms of the promise with reasonable certainty, and that is signed by the defendant. The plaintiff doesn't usually have to sign in most states. Now, those are the general rules concerning statutes of frauds. Now, how do they play out in cases? Well, there's usually a standard pattern of argumentation. The plaintiff's claim is that the defendant made a promise and didn't keep it. The defendant's defenses are essentially that the promise is not enforceable because it falls within the scope of a statute of frauds and the requisites of writing and signing have not been met. For example, the defendant might say there was no writing, or the writing does not state the essential terms, or the defendant did not sign the writing. Now, the plaintiff has 3 responses. First, the plaintiff may say that the promise actually does not fall within the scope of any statute of frauds. We've seen this before. For example, the promise does not meet the definition of a surety promise, as we saw in the Longman v. Alumni Association case, or the promise could in fact be completely performed within a year, an argument that was made in the Cohen v. Orsinger case. Second response is that the defendant is equitably stopped from denying the existence of a sufficient signed writing because the defendant asserted that a sufficient signed writing had been made and the plaintiff relied on the defendant's assertion. Third, pursuant to the part performance exception for land contracts, the defendant may not assert the statute of frauds as defense because the defendant promised to convey land and the plaintiff substantially relied on the promise. We saw that in the Johnson Farms v. McEnroe case. The final response the plaintiff might make is that the defendant may not assert the statute of frauds as defense because the plaintiff relied on the defendant's promise and injustice can be avoided only by enforcement of the promise. That's the argument that we saw in Monarco v. LaGreco. Some courts accept this argument, but not all courts do. Those are some of the rules that we've learned concerning statutes of frauds. Thank you very much for listening.